What is a summons and complaint? Welcome to our YouTube video series on legal terminology. In this particular video, we will be looking at the legal concept of the summons and complaint. The default rule to commencing a civil court proceeding in most jurisdictions of the United States is to proceed as an action through a summons and complaint, known as an originating process. The summons informs the recipient, known as a defendant, that they are summoned to answer the complaint that is being concurrently served upon the defendant, or where a complaint has yet to be filed and served, to serve a notice of appearance, failing which judgment could be awarded against the defendant. The complaint outlines a series of facts that, if proven, could grant the party commencing the action, known as the plaintiff, a remedy, typically damages. For example, if a person claims that another person has breached a contract, and as a result the claimant has suffered damages, the claimant could allege facts that there is a contract, the terms of the contract, and the amount of damages claimed to have been suffered as a result. The summons tends to be largely generic in its form, being dictated by the court before which the action is intended to be argued. As such, in New York State, the summons is set out on established court forms with the following content. Quote, "The above named defendant," specifying defendant's name and address, "you are hereby summoned to answer the complaint in this action and to serve a copy of your answer, or, if the complaint is not served with this summons, to serve a notice of appearance on the plaintiff's attorney within 20 days after the service of the summons, exclusive of the day of service, or within 30 days after the service is complete if the summons is not personally delivered to you within the state of New York. And in the case of your failure to appear or answer, judgment will be taken against you by default for the relief demanded in the complaint." The basis of venue is specifying basis for choice of venue, which is specifying facts supporting the choice of venue, such as the plaintiff's address. The complaint is drafted by the person initiating the lawsuit, known as the plaintiff, or their lawyer, and must follow the format established by the particular court before which it is intended to be argued. The jurisdiction's consolidated laws, in particular those pertaining to court proceedings and practices, like the New York Civil Practice Law and Rules, are an essential starting point for drafting the complaint. Before one can serve the summons and complaint, it must be issued by the court. The summons and complaint is issued by the Registrar's Act of dating, signing, and sealing it with the seal of the court and assigning to it a court file number. The claimant must file a copy of the summons and complaint with the court when it is issued. The claimant can issue the summons and complaint either by direct personal attendance in the court or by someone on the party's behalf, facsimile transmission, or electronically. The claimant must serve the statement of claim shortly after it is issued. If the claimant uses an incorrect method of service, are unable to prove that service was made, or fail to serve one or more parties, the claimant might not be permitted to file their legal documents with the court. The inability to file the claimant's legal documents with the court could result in missed deadlines, or at the very least, unnecessary delay resulting from reserving required legal documents. It should also be noted that there are different types of civil court proceedings, such as unlawful detainers, applications for injunctions, etc., which may have different dates to respond. The return date of a summons is a date to respond or face default. Furthermore, different courts have different forms and different time limits. Upon the summons and complaint being properly issued and served on the defendant, the plaintiff can invoke the full power of the civil courts to obtain relief. Ignoring the summons or refusing to comply poses the risk of default and can threaten the defendant's property. And once default is entered, the defendant cannot simply choose to appear. The defendant must now file a motion to remove the default and explain to the court why they failed to appear prior to the expiration of the court-mandated time period. The court has discretion to refuse to remove the default, and after a certain period of time, i.e., 6 months in certain jurisdictions, even the court's right to remove a default is extremely limited. Defaults can be reduced to a judgment, and with a judgment, the plaintiff can seize property owned by the defendant, garnish wages, obtain an eviction, etc. Thank you.